Hi, thanks for tuning in to another edition of Lawcast. I'm your host, Adam Wright. Each podcast, we bring you different information that affects a different part of personal injury law. As we say each time, everybody's different, and your case may be very different from somebody else's. So make sure that you use the information presented here as a guide, and then make sure you talk to one of our lawyers in order to get information specific to your case, because again, every case is different. Today, we're going to talk about product liability, and that's an area of the law where manufacturers and sellers are held responsible for injuries their products cause. And today, Enrico Maio, one of the attorneys here at Pellegrini, Seeley, Ryan, and Blakesley, will help break this down for us. Hey, Enrico.
Hi, how's it going, Adam?
Good. So, as I understand it, there are three major types of product defects. What are the three major types?
Sure. The three major types of product defects are 1, manufacturing defects, 2, design defects, and 3, failure to warn defects. And, products could actually have one or more of these defects.
Well, let's take it from the top and kind of go through and see how they differ. Talk a little bit about manufacturing defects. What's a manufacturing defect?
So a manufacturing defect is where a product differs from the others in the same assembly line and does not conform to the manufacturer's design, which typically means that the defective product is likely missing parts, has the wrong materials have been used, it was installed or assembled incorrectly, perhaps machined incorrectly, and when we're dealing with electronics, programmed or calibrated incorrectly. So some examples of those that I've seen in my practice are and pursued claims for, screws missing from chairs where people have fallen and been injured, the incorrect wiring used in a heating pad that, led to burns in a fire. And I've also seen a torn rubber gasket in a pressure cooker, which caused a massive explosion, sending hot liquid scalding onto one of my clients.
Wow. So basically, this is a one-off, although I suppose it could occur for many products within that line, but something that's being manufactured where there's a mistake. It's not inherent to the design of the object. It's just an error by the person manufacturing it.
Correct. It's out of spec, whether it's whether it's handmade or even the machine that's making it. It's different from the others.
Got it. Okay. Design defects. What are those?
Yeah, design defect is a little more complicated. It's where the product as designed is inherently dangerous, no matter how carefully it's been manufactured, even if it's been manufactured to spec. And it's the difficulty with these cases is that the injured party has to prove that there's a more feasible, cost-effective, and safer alternative to the design that's been used.
What are some examples of a design defect?
In cases that I've seen here at the office, one of the more common ones is where we find that guards haven't been used. For example, a safety guard on a power tool, which allows somebody's extremities to come in contact with a sharp object like a blade, and somebody loses a finger, a hand. So we've seen those type of injuries here at the office. I had a case where, a manufacturer designed a certain microwavable food container, but it melted and warped under heat. And so what would happen was when you went to remove it from the microwave, it would sort of collapse upon itself, and it would, discharge the food or the liquid that was scalding hot, causing burns. And some other ones that we've seen are, furniture that's been designed that is top heavy, and that's fallen and caused crush injuries. So now you see, some of these pieces of furniture are being sold with
anti-rock devices, right?
Exactly. Wires and harnesses that you strap to the back of it to ensure that, they don't collapse or fall, particularly when young kids are trying to climb everything around them.
I got to think those design defects, and I think you sort of alluded to that at the top, is that it's got to be a very difficult case because you have to bring in, engineers that can tell you that this is, or they can prove that this was designed incorrectly.
Correct. I mean, these are, like I said before, difficult cases to prove. They can become very expensive cases to pursue because you do have to find experts to, essentially look at the product and say, hey, it could have been designed safer and, it's cost effective, meaning, wouldn't cost so much so that there's no point in making the product. Now you can't earn anything by making the product.
Is this something that we see a lot of class action cases about? Class A?
I think in the vein of
because I'm going to think it's very expensive to go after a manufacturer for one particular incident, but there are likely many people who have been injured by that same defective product.
There can be. I would say that typically you might see that in the case of medications. So where you've got a lot of people taking them, and that's, slightly, it kind of rolls into the next type of defect, which is a failure to warn. And like I said, you can have more than one of these defects in a case, but you see more class action cases when you're talking about potentially medical products or medications. Because you have a lot of people using those products, and they're ingesting them, they're taking them into their body, and therefore more prone to suffering the risk of the design defect or the failure to warn. Whereas, you might have somebody, where a guard is missing from a product, but, more people tend to just be cautious in nature and don't put their hand near it. But it only takes one, I guess. So.
Right.
I would say less class actions for the design defect.
And failure to warn, as you mentioned, is when there's a non-obvious danger, right? And there's not some kind of a disclosure.
Well, yeah. I mean, it's where we have a product that carries an inherent non-obvious risk that's known to the manufacturer, but not necessarily known or obvious to the patron who's purchased the product. And, there's an obligation for the manufacturer, the seller, the distributor to, warn the ultimate purchaser of the product and thereby reduce or eliminate, the occurrence of this risk. And you typically see that where they don't produce or provide instructions on the issue or warnings on the issue. In some way, the materials that come with the product are defective. They don't talk about it, or they don't draw obvious attention to it.
And is it just that that they know, the manufacturer knows and has a failure to warn, or that they should have known? In other words, did they rush something to market without knowing? But they should have known.
Well, we're kind of getting ahead of ourselves in the sense, so we'll talk about that in a second. But the theories of liability, there's, three different kinds. There's negligence, strict liability, and breach of express or implied warranties. And yes, under a negligence theory, you would seek to determine what the manufacturer knew or should have known, whereas in strict liability cases, we're not even concerned with that. And so state by state have different rules on what type of claims you can make. Strict liability claims being easier claims to pursue because we're not worried about what the manufacturer knew or should have known or what they did or didn't do. It's, hey, is the product defective?
So, you can't turn on the television without seeing, every 30 seconds, a ad for medicine, and the description of the potential side effects are pretty extreme. Is that in reaction, or when you get something from the pharmacist and it comes with a booklet the size of an encyclopedia that lists all the potential things that could go wrong? Is that in response to failure to warn lawsuits and trying to protect themselves?
Yeah, I mean, there's over many, 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 many years, that has become the case. You see those commercials where they laundry list every type of thing that, might occur from a medication. And obviously there's pros and cons to taking medications, right? You've got to take it, but there are risks. And in order to properly evaluate whether those risks are appropriate for you, you need to know what, the negative consequences might be. And so, yes, that is exactly what it's a response to, is that, these manufacturers know or should know about certain risks. And, before you ingest something, they've got an obligation to warn people that, how it might interact with other drugs they're taking, or just, cause side effects to be aware of so they can do something about it if they occur. So, yeah, I mean, that's exactly what a failure to warn a defect is trying to curb, is, people putting products out in the market that, are, inherently dangerous, where, the manufacturer, needs to, protect the patrons who might not have the savvy or the know-how or the scientific knowledge that they have.
Sure. Which is pretty much everybody.
Yeah.
Yeah. You mentioned that there are three different kinds of liability claims, or at least three categories that liability claims fall into. Can we go through those one at a time?
Sure. I mean, there's three types, like I said before. There's negligence claims, strict liability claims, and breach of warranty claims. And again, just like there are three different types of major product defects, and a product could have, one or more of those, you can have one or more different types of claims you can pursue. And so you could have a negligence claim only, you could have a strict liability claim only, or you could have a breach of warranty claim only, or you could have all three. And some of it is state dependent on what your particular state allows for. But most states allow for all three at this time. It didn't used to be the case. Massachusetts does allow for strict liability cases, which is an easier claim to make than the negligence claim that we had discussed earlier. Because in negligent claims, we're kind of somewhat concerned with what the manufacturer, the seller, distributor knew. Did they have a duty of care to the plaintiff? Did they breach that duty of care? And was the breach the ultimate cause or proximate cause of that plaintiff's injuries? On strict liability cases, we're not concerned about that. We just want to know, was the product itself defective, without any care as to, what the manufacturer knew or didn't know. So it's an easier claim to make. So that is a typical claim that you'll see as a strict liability claim. But again, the plaintiff will throw in negligence and breach of warranty where applicable. We haven't talked about breach of warranty claims. They come in two forms. Those are express warranties and implied warranties. And just as it sounds, an express warranty focuses on actual written or verbal statements made by the manufacturer or seller concerning the product. Mm-hmm. So, a typical example would be, and we've seen this numerous times, is where a label and says something like, hey, this is a nut-free product. And, you purchase it for your family member who, has an allergy, and they eat it. And lo and behold, all of a sudden they can't breathe and they're in anaphylactic shock, and you rush into the hospital and come to find out it wasn't nut-free. I mean, that would be example of a breach of that express warranty. Implied warranty is just a little different. They cover those expectations common to all products in the market, in that we all expect the product not to be unreasonably dangerous for the purpose it was intended for. Another example that we've seen, over the years here in the office are ladder cases. Mm. One expects when they purchase a ladder that it's sturdy, stable, and sometimes based on the way that they've been designed, they're inherently, unstable or wobbly. And, when you're up 8 feet on a ladder, that's a fall hazard. So, those are the type of things that are not necessarily, expressly warranted by the manufacturer, but that the average person would expect the product to be, safe, stable,
right,
not wobbly.
Right. No, that makes sense. If you've been injured by a defective product, what's important in terms of preserving your ability to bring a successful case? In other words, let's say somebody is hurt off of a ladder, or they've taken something that is something, or they have a product that has failed in some way that has injured them. What should they do in order to preserve their claim?
And I think this is probably the most important, thing we'll discuss today is, what to do if you've actually been injured. The rest of it is really what I worry about.
The legal aspect,
but
sure.
The things that, a client that's been injured should be focusing on immediately are, these things here. And the first thing I would say is save the defective product in the condition that it was last used. Don't alter it. Don't destroy it. Don't dispose of it. We get a lot of calls sometimes, and we hear, I was injured by, this product a year ago. I don't have it anymore. Then unfortunately, we probably can't help you. We need that product. We need to have potentially an expert look at that product, test that product and write a report as to why it was defective. And without the key piece of evidence, you may, eliminate your ability to recover for those injuries. I mean, another thing that we see is sometimes before clients get to us, they will reach out to, the seller, the manufacturer, and, tell them, hey, I was injured by your product. And a common tactic by these manufacturers or sellers is, oh, well, send us the product back. Let us take a look at it. Do not do that. Because once that product leaves your possession, who knows where it goes, and you've lost your key piece of evidence. So again, I think the most key and salient point is that you must preserve the product in the condition that it was in. And so, moving on to something else that's also important, which goes to our, failure to warn type of defect. Any and all paperwork or materials, even the packaging that you still have in your possession at the time you're injured, don't dispose of it. We want to review that information when we're evaluating a case. What did they tell you? What did they not tell you? Were the warnings sufficiently obvious, or were they buried in, 30 pages and, we're not drawing attention to them? So keep that information. That is something that also your attorney is going to, want to have. Another thing is to take pictures or videos of the defective product. So, just in case, the product, your mother, your father, your aunt, says, oh, what's this? And throws it out. At least potentially, maybe we have a picture or video of it, right. Worst case scenario. So take pictures and videos of the defective product, focusing obviously on what, the defective part was, but also on any labels or decals that are on the product. That's going to tell us potentially the make, the model, the manufacturer, who we're going to go after.
And of course, with almost any injury, make sure you get to a medical professional that can help get you stabilized and keep your records, your medical records.
Absolutely. I mean, it's if you've been injured, and this is every case, not just right. Our product liability cases that we handle, but if you've been injured, it's important that you don't sit at home in silence, depending on the severity of injury. Obviously, if you've lost a finger, we know you're going to the emergency room right away. But sometimes people, suffer in silence and they wait, weeks or months. Oh, I think it might go away. I think it's important that if you're not feeling well and you've been injured as a result of somebody else's negligence, whether it's a product or a motor vehicle accident or a slip and fall, you're not feeling well, go get checked out. That way, at least it's documented that you are not feeling well, that you've been injured, and somebody can't say to you later on, hey, how injured were you? You didn't go see somebody, right away. Well, a lot of people, that's not their first instinct is to run right to the doctor. Some people are, like to suffer in silence, like, my parents, they don't like to go to the doctor, but, they'll tell me all about their injuries. So, right. But it's a common tactic or refrain you'll hear from defense counsel. Hey, why didn't you go? Well, a lot of people don't because they don't like to go to doctors, but it's important, that you go and get it documented for the purposes of your claim.
And of course, talk to a lawyer. I mean, one of the things that people often tend to do is wait until it's too late, until they've thrown something out, until they've contacted the manufacturer, or until they've had a statute of limitations run out.
Right. And so that's the other key piece. After you've done these other things, you should immediately contact a lawyer, someone like myself or, my fellow colleagues, and we'll walk you through, the process, what you should be doing, what your rights are, including, protecting you from some of the things we discussed, keeping you from disposing of or returning the product to the manufacturer, making sure that we provide any proper notices within a timely fashion that are required under the law. Sometimes you fail to make notices, in certain types of cases, not just product cases. And, if you don't make that notice to the right person within so many days, you lose your ability to bring a claim. So again, we will walk you through what you should be doing. We will help preserve the information we need to bring your case successfully and find the right experts to review, products. So yes, I mean, after you've done all those other things we talked about, the next call should be, to somebody like myself who can help you through these things.
And I know a lot of people are nervous about calling a law office, how much is it going to cost me? And we always say, look, call us. All our consultations are free. It won't cost you anything, and it could save you a lot of aggravation and a lot of money.
That's true. I mean, we don't we don't charge anyone to talk to them, to review their case. That's all part of the process in helping us help you. So, there should be no concerns. There's no pressure. It's all about, helping people out.
Yeah. Rico de Maio, a lot of information, and we really appreciate you coming by today. If, again, you've been injured by a product or had an accident and you want to reach out to Rico, you can do that by calling 800-785-5399. And we really appreciate all the information. Thanks.
Thanks, Adam.